Hi, I'm Jason Sullivan of Rathbone Group, and this is on Subrogation. This video discusses PIP benefits in Florida. We have another video that specifically covers when subrogation opportunities exist, when a tortfeasor is uninsured, or when a commercial vehicle exception applies. PIP is personal injury protection, and in Florida, that covers up to 80% of the reasonable and necessary medical expenses incurred due to a motor vehicle collision. There are a lot of technical rules and the statute's quite lengthy, so if you have any questions, please refer to an attorney or consult the statutes yourself. As an overview, you need to have a couple things happen to be entitled to PIP benefits. First, PIP benefits will cover initial treatment as well as follow-up care and treatment. You must receive initial treatment, and that's either from a doctor, a chiropractor, a dentist, an advanced practice nurse, or at a hospital or hospital-owned facility within 14 days of the accident or injury. If you've done that, then you're entitled to at least the $2,500 benefit and potentially up to the $10,000 benefit for those reasonable expenses. The difference between a $2,500 benefit and a $10,000 benefit is whether you've been diagnosed with an emergency medical condition. That emergency medical condition is something that shows that you have acute symptoms of sufficient severity, including pain, that if in the absence of immediate medical attention, it's reasonably expected that you'd have serious jeopardy to health, serious impairment to bodily function, or serious dysfunction of a body organ or part. In order to have a diagnosis of an emergency medical condition, that must be done by a licensed physician, a dentist, a physician assistant, or an advanced practice registered nurse. In that case, if you've been diagnosed with that emergency medical condition, then you may have a right up to $10,000 of the PIP benefit rather than just the $2,500. And again, you must receive that initial care treatment within 14 days of the loss to be entitled to either benefit. So if you're a subrogation professional and you have a claim, you may have defenses that there's no PIP subrogation because there's not an uninsured motorist or there's not a commercial vehicle exception. But let's say you've overcome that hurdle. You do have that commercial vehicle exception. But now the other carrier is starting to dispute should you have paid PIP at all and whether or not you were entitled or obligated to pay the $2,500 benefit or up to $10,000 benefit. So let's attack these each as they may come up. If you've already overcome the commercial vehicle exception, then you're looking at whether or not your company was obligated to pay PIP. And if your insured did seek that initial treatment within 14 days, then they are entitled to at least that $2,500 payment. It should be pretty easy to determine whether or not initial treatment was sought within the 14 days based on the medical records and the timing of the treatment. If you can overcome that, then the question is, did your insured have an emergency medical condition diagnosis or determination by a properly authorized individual? This gets complicated in Florida because there's no form, there's no specific language. It may not necessarily be on the mind of the ER doctor to put forth language or sufficient information to make that determination. But if your company's already paid out more than a $2,500 benefit, and now you have another carrier or vehicle owner saying, no, you shouldn't have paid that because they didn't meet that emergency medical condition standard, the good news is that diagnosis and that statement does not have to be obtained within 14 days of the loss. In other words, even if it's been a year since the PIP payments have been made and now you're getting this defense, you should be able to go back to the medical records and those medical providers, if they qualify under the statute, to make that determination that yes, there was a medical emergency condition that existed for this patient based on these injuries and the treatment received. And had they not received that because of the serious impairment to their body or its function or an organ, if they had not received the treatment, that would have been in serious jeopardy. So you always want to look at what exactly is the argument that there is no PIP subrogation. If you can overcome the initial, there is no subrogation for PIP in Florida because of, let's say, a commercial vehicle exception, then you want to find out exactly what the dispute is. Are they disputing the necessity and reasonableness of the treatment? Are they disputing the amount that was paid and it should have been a lesser benefit because there was no emergency condition determination? then you can begin to tackle those. And it may require going back to those providers and your insured to get that authorization and release of information to then make the case that the other carrier needs to pay the full amount of the PIP back to you under the reimbursement statute. If you have any questions on PIP in general, or you have a topic you'd like to see us discuss, please contact us at video@rathbonegroup.com. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.